Good evening and thank you for joining us on Sunday Interview. I'm your host, Grevazio Zulu. In 2017, opposition Christian Democratic Party leader Dan Pule and 3 others petitioned the Constitutional Court to declare President Edgar Lungu eligible to stand in the 2021 general election. Almost 2 years after the ruling on the matter in 2018, political debate has continued on the tenure of office for President Edgar Lungu and his eligibility to contest as presidential candidate in 2021. Political parties, civil society and lawyers do not seem to agree on a common position over the Constitutional Court ruling, as well as the provisions of Article 106 of the Constitution of Zambia. Today on the program, we ask the question, should the debate continue, or is it time that people ended the talk and moved on? My guest, Lukasha Member of Parliament and former Law Association of Zambia President, George Chisanga. Sir, welcome to the program.
Thank you very much, Mr. Zulu. I'm delighted to be here.
You are a new Member of Parliament. Maybe I should ask you to briefly talk about yourself. Who is George?
Right. As you stated, Mr. Zulu, I'm the now recently elected Member of Parliament for Lukasha constituency, having been elected into office on the 17th of September 2020. My brief background is that I'm a legal practitioner by profession. I trained as a lawyer in Zambia at the University of Zambia, after which I went and pursued a higher degree in Master of Business Law at Cambridge University. I have a practice experience of 27 years. I worked both in private practice and I was employed as legal counsel. I worked in a law firm called DH Kemp & Company when I started, and then I joined Stanbic Bank, where I established the legal department in the bank. After serving Stanbic for some 4 years, I went to Kenya, where I worked for the PTA Bank for another 4 years. And when I left, I considered the retirement from former employment and set up my own practice called KMG Chisanga Advocates, which I run up to now. But now, being Member of Parliament for Lukasha, I'm considering proceeding on leave so that I can serve the people of Lukasha constituency.
Well, that's an illustrious career in the legal industry. Yeah. Yours has been a long walk to Manda Hill. I know you attempted Matero way back. Yes. 2001? 2001, yes. And Lukasha, you intended to stand 2011, you were not adopted, yes. And you never lost faith, kept on trying.
That's right.
What is the drive behind?
I think for me, it's a passion to serve. That's what motivates me. I consider myself somebody who is able to give service, and when I'm called upon, or if circumstances call upon me to serve, you know, I present myself as a person who would like to serve. My political career goes back to the time when at the University of Zambia. At that time, we actually didn't have any union politics, but we were basically spontaneous. You know, when a group is not led, you can do almost everything. And if you recall history, it's recorded that we staged the 1990 student demonstration that ended the one-party state when the country only had one party called UNIP. And the country then transformed into a multi-party state system. At that time, I assisted one of the very illustrious lawyers of the time, Mr. Samuel Mianda, who was a Member of Parliament for Matero. I used to admire that gentleman from a distance, and when he asked me to help with the campaigns in Matero, that's when I entered politics as one of his youths. We campaigned very ferociously for him, and he won. For me, up to now, Mr. Mianda remains one of the politicians that I admire very, very much, and I think unless I'm slipping up on history, he should be the only MP who was elected in Matero constituency twice. He's the only one who's run 2 terms for Matero constituency. And that's what actually motivated me to contest Matero constituency in 2001 under the flagship of the National Citizens Coalition. Then Dr. Nebas Mombo was our president. Unfortunately, I was trounced. FDD won that election. I then was persuaded to join Patriotic Front by Mr. Michael Sata and with Mr. Winter Kavimba, and that's how I've been a member of the party from that time up to now. The motivation to go and contest Lukasha constituency, I think, was infused into me by Mr. Sata when we were still in the opposition. You know, because when he set up this party, one of his intentions was to try and bridge the gap between the rural areas and urban areas. In his understanding of one Zambia, one nation, it meant that if Mr. Grevazio Zulu can have a tarmac road in Avondale, there must be somebody in our village who should also be able to have a drivable road so they can carry out the economic activities. So it will bring a bit parity between, you know, those who live in urban areas and those who live in rural areas. So in the discussion that he had with me, he told me, don't restrict yourself to being an MP only here. There are places where you can go and serve and serve very well. So we identified Lukasha constituency because that's where I actually hail from. And I've been working in Lukasha constituency from 2006, to be specific.
It's about 14 years ago.
That's right.
Well, now you've entered from law practice to politics, and you've joined the parliament at a very critical time,
Yes.
maybe exciting time, I should say. You met up with the debate on Bill 10.
That's right.
Straight into the budget.
That's right.
Debates
Yes.
and adoption. Have you managed to find your feet?
In fact, there's been no time for merrymaking. I mean, we were being elected when Parliament was in session. In fact, what excitingly happened is that the time they declared me as a winner, I was then instructed immediately to go and join and swear in and begin to participate in the debates. So there's not been a time to break up. But I can tell you that I had been prepared for this. I was actually considering to contest in 2021 and the Patriotic Front. So I'd been doing some work in the constituency, getting ready for it. So when this misfortune of the death happens in the constituency and I was invited to contest, I accepted the assignment. It's not been smooth sailing, but I think it's been a very good settling, because I think I'm shouldered by very effective members of parliament. We actually got a caucus of members of parliament from Northern Province, where there's Honorable Chungu, who's the minister for the province, there's Honorable Munduvile, and my twin brother, Kelvin Sampa. So they've actually helped me to settle very, very well in the constituency. The transition from practice to the politics has been okay, because I must say here that I haven't actually been very active in practice for some time. I have trained my children to be lawyers, and I've also grown the law firm. So there are people that are actually serving at the law firm if I'm away from it.
Now let's get down to the topic for today. The debate on the eligibility of the president, President Lungu, has been reignited as the nation draws closer to the constitution, to the polls in 2021. Is this the debate people should be having? Do you think we should be having this debate?
In my personal assessment, this is not a debate that we should be having. I think the nation must just begin to ready itself. The political parties must begin to prepare their candidates for the next election, so that when people file their nominations in quietness, we go out and sell ourselves to the electorates and allow them to pick a candidate of their choice. I think this is not a debate we should be having.
Let's look back at the history. In my introduction, I talked about the case which has now been named Danpule and others versus Attorney General.
That's right.
What was the genesis of this case, and what question did Dr. Pule take to the Constitutional Court?
Yeah, just a brief background. I mean, you realize that Dr. Edgar Chagwa Lungu, His Excellency, was elected through a transitional period in a constitutional order that we have. We had a constitutional amendment in 2016, and we were under a different constitution when the first elections took place. So there was this transition that took place, and he was elected twice within a space of 1.5 years. And the topical issue that has now arisen is whether, having been twice elected, he should not be allowed to contest the election again. And because of the disquiet that was taking place around communities, it was decided out of prudence by the litigants to go to court to go and get a determination of whether, having then been twice elected, or looking at the constitutional provisions then as they existed under the 2016 Constitution, he should not be allowed to contest the 2021 election. And the wisdom that the litigants used was to take this matter to court, and the questions they put before the court were very simple and basic. The first one was basically whether His Excellency Dr. Edgar Chagwa Lungu would have served full 2 terms under Article 1063 and under Article 1066 of the Constitution of Zambia at the expiry of this term that is serving now. And the second question was whether, as a matter of constitutional law of the Republic, His Excellency then was eligible for re-election for a next 5-year term, which now ends on the 13th of September 2016. These are the issues that were brought to court because there was need for a determination of somebody who goes in to finish a term of the deceased president and then wants to contest on his own terms in the new terms. And that's a question that the litigants brought before the court.
Now, when you look at the judgment and the ruling, you discover that the court decided to rephrase the question.
Yes.
And they, according to the court, they ask whether, in terms of Article 1063 and 6, a presidential term of office that ran from 25th January 2015 to September 13th, 2016, and straddled 2 constitutional regimes, can or should be considered as a full term. Why did the court rephrase that question?
Yes. First, I must mention here that it's not unusual for the court to rephrase questions. I know there's been a debate around whether the court has got the mandate to actually change a question that the litigant puts before the court. Now, jurisprudence will show you that actually courts do have that jurisdiction. Okay, if it deals with matters that involve individual rights, i.e. civil proceedings before two parties, the court can ask you to go and amend your pleadings. But if the court is dealing with a constitutional issue or an issue of public interest, and they would like to make a final determination on the issues brought to the fore, they have the power to either do either of the two things. Sometimes courts have made decisions in what is called obiter dicta, where they themselves say, look, if the circumstances that were presented before the court were like this, we would have decided the matter in this fashion. Or like they did in this matter, because they wanted to make a determination which sort of binds the whole nation. They didn't want to create a scenario where anybody who finds himself in the circumstances where Dr. Lungu finds himself today would have to come back to court to make another determination on issues that have already been litigated upon, deliberated upon, and the court decision has been made. So in order for them to achieve that objective, they then decided to rephrase the question to make a decision that is final. So it is not unusual they would actually that
make a decision. No, you've read the ruling. Why is there talk that the court did not declare the president eligible?
I think it's a question of the schools of thoughts that have risen out of this decision. You know, there's a school of thought that believes very firmly, and I belong to that school of thought, I must say immediately, that the court did pronounce itself on the issue of eligibility. And then there's a school of thought that thinks that has come up with the conclusion that the court did not make that deliberation. But if you read the judgment towards the end, the court actually pronounced itself on that issue, and for us we consider it a final decision. But this has arisen because you look like any other matter of public interest, like any other matter which of a constitutional nature. Usually two schools of thoughts arise from a determination of this nature.
But is it healthy to have a ruling that is so divisive as this?
The ruling is not divisive. It's a question of how you interpret it. You know, insofar as this ruling is concerned, all the matters that were brought to the fore, including the question that was rephrased by the court, were decided determinately.
Because we are seeing here civil society, a number of civil society organizations, I think including LAZ, they've all stated that the court did not pronounce itself on eligibility. It pronounced itself on terms.
Yes. Look, this country has become highly politically opinionated right now, and I should have first curtailed myself before starting to speak that I'm sitting here, yes, as a former LAZ president, but I'm sitting here as a member of parliament for Kasha constituency. So what I say here is not a position for LAZ. I know the official position for LAZ, but I don't think it's very different from our position, because our position is that the court made the determination on the question of eligibility. You know, the last statement that was recently issued, I think, does not depart radically from the position that we've taken ourselves, because for us it is reading this judgment and seeing the conclusion that the court drew on its interpretation of Article 106 of the Constitution.
To the court's interpretation, people have restricted it and saying the court pronounced itself on the presidential term served between January 25th, 2015 and 13th September 2016. And it does not go far to now state that he's actually eligible.
Well, the court had to determine the matter of how you interpret Article 1063 together with Article 1066. That's actually why they rephrased the question. Because they needed to, like I said earlier on, they needed to make a decision that is very final. There was, I think, an attempt to try and bring in the Republican president into this action, and the court decided they were not going to do it because this matter was, they were just going to determine a matter that was of public interest. It didn't matter whether they should bring in the president or not. And in any case, anybody who's sitting in the office of president currently has immunity, and you can't bring somebody into litigation, you know, when they're enjoying immunity. But what they needed to determine was whether the interpretation of those clauses meant that a person who has served the presidency in the manner Dr. Lungu is serving would be ineligible to consider, you know, applying for re-election in the subsequent years. And in their final determination said, no, actually that is not the case. He is eligible to conduct.
Do you think it was a good move by the courts to remove the name that the litigants had put
Yes,
in
it
there?
was.
Because they wanted clarity.
Yes,
and
it
then
was.
By removing the name, they removed the aspect of clarity.
Look, it was very clearly and very fairly, and in my assessment, very, very justly. You know, this is not an issue of Dr. Edgar Chagwa Lungu alone. This is an issue of the office of a president. There will be other presidents who will come. There have been presidents who have been there before. First, like I stated, you can't take a president who's sitting at State House and who enjoys constitutional immunity and bring them to court to litigate. It doesn't work that way. The only way a president can bring himself to court is, the only way the president can remove their own immunity when they are sitting is if they themselves choose to litigate.
But in this case, were they taking the president to court?
The president wasn't
not necessarily, but the name was there.
Yes,
it should have been left there, and then people could have used the judgment as a precedent in any other future cases.
It would have been very unfair to have the court make a determination and the judgment with the name Dr. Edgar Lungu on the litigants list when he himself was not before the court. And also he was enjoying immunity, he continues to enjoy immunity up to today. What the court was trying to do was make a policy pronouncements on the constitutional interpretation of the clause that deals with eligibility, transition, and whether somebody can be re-elected in the circumstances that the current president, became the president of the republic and ran the first term to finish the deceased president's term, and then what does it do with his rights going forward?
In your view, is the declaration that people are talking about, whether it's eligible or not eligible, do you think it was just inferred or it was categorical in the ruling?
It was very categorical. The question of the way they made it categorical is when they said you cannot, interpret Article 106 in isolation of its sub-articles. And that is a correct constitutional interpretation. If you have to interpret a statute, you must take all the clauses into consideration. The attempt, like I said, that I'm seeing in the debate is that if you are only going to consider Article 106, sub-article 3 in isolation, then you lead yourself to what I consider a fallacious conclusion that actually somebody like Dr. Edgar Lungu does not qualify. But like the court guided, you have to read all the clauses at the same time. And in their reasoning, if you put those clauses together in one interpretation, you will discover that actually he is eligible. Because the intention of the legislature in passing this constitutional provision, even when there was a straddle in between, was that if you are elected to finish somebody else's term, and that term does not exceed 3 years, less than 3 years, that should not disentitle you from contesting in subsequent years. In other words, your first term should be considered when you go for re-election after you finish the term of the person that you succeeded in office. And that is what people wanted. That is what those who submitted to the technical committee actually submitted. And you must remember that when the technical committee was sitting, I was sitting in the office of LAZ President, and we had membership of the technical committee. So we were always alive to what the people wanted in terms of creating this constitutional transition when one president dies in office and the other one takes over. And this was achieved, and I think the court was very correct in interpreting in that fashion.
There's a debate on just one word,
yes.
And people have held on to that,
yes.
and their argument maybe can be justified. They're saying the statement, according to the Constitution,
yes.
Article 1063, it says, once you're elected twice,
yes.
you're not eligible to stand. And it's
yes.
very clear,
yes.
elected twice.
Yes, yes. That is if you choose to read the Constitution in isolation. You would definitely draw that conclusion. But it is not correct to isolate constitutional provisions in interpretation. You must read the others that deal with the same subject matter. Article 1066 is a conclusion, is a completion of what is in Article 1063, because Article 1063 only deals with a person who is elected in an ordinary election. So you are elected twice to 2 5-year terms. But if you are elected twice, and one of the terms in which you have been elected is just to complete a less than 3-year term of the deceased president, that should not be credited to you in determining whether you're eligible or not. And that's what the court has been, that's what the court reasoned, and that's how they drew their conclusion at the end of the judgment. That elected twice would only apply in the event that you're talking about 2 terms being 5-year terms, both of them. But if elected twice, it relates to 2 terms, one of which is less than 3 years. Then you go to Article 1066, which tells you that if you are elected to go and finish somebody else's term, and that term is less than 3 years, that should not be credited to you when you're considering for the election in subsequent years. So that if logically you understand those clauses, then your first term should be considered when you are elected to start your 5-year term as a president.
So here, the people that are countering your arguments are stating clearly that the Constitution does not talk about terms. It talks about holding office,
yes.
and talks about being elected. So you're elected twice,
yes.
You've held office twice.
Yes.
Isn't that very clear?
That is actually
straightforward.
It's not even straightforward. That is straightforward if you want to go all the way up to 50%. You should also look at the clause that talks about what happens if you are elected to go and finish somebody else's term. If you are elected to go and finish the term of a deceased president for a period of not more than 3 years, that should not be credited to you. So that if you take these 3 clauses and interpret them together, you will discover that the intention of the legislature, and this is how the reason of the court was at the end, the intention of the legislature was that if you are elected to go and finish somebody else's term and you remain in office for less than 3 years, you are then entitled to begin your year in the subsequent election where you start running your 5-year term. But the intent and purpose of the Constitution is to restrict the electability, the twice electability concept to one who serves the 4 5-year terms, or at least one who serves 3 years plus the 5 years that is going to be subsequently elected in. But if you serve anything less than 3 years, like Dr. Lungu did for Mr. Sata, then you shouldn't have that credited to you.
There's an argument, but I should quote Counsel John Sangwa, Counsel, who has belabored to explain that the clause that you're looking at, which talks about the 3 years, relates to the Vice President, who assumes office when the President dies. And
yes,
doesn't speak to the President.
You should look at the two constitutional orders. In the current constitutional order, if the President dies in office, it's automatic that the Vice President will take over without an election. That the first election that took place for Dr. Edgar Lungu was under the previous constitutional order, which is why the Constitutional Court was dealing with the issues of straddling between one constitutional order and the second constitutional order. If the President died today in office, the President who takes over will run the rest of the term. And under the new constitutional order, it's only the sitting Vice President who can actually succeed the President who's in office currently. But under the old constitutional order, any other person would do, which is why there was that transitional period of 90 days where Dr. Guy Scott acted as President, and we went to the polls and somebody was elected to finish that term. So that argument, for me, I don't agree with it.
So do you think maybe in this case, should President Lungu go back to court to seek clarity on the matter?
Why should he go and seek further clarity? The decision that they are referring to makes it very clear, categorical, that he's eligible to stand. There is no point in him going back to court.
Because there's an issue of words here. Twice elected, and people now are saying, well, we'll wait for him to file in the nominations. Does this create uncertainty?
If for me, I had made a statement earlier on, and I think I can only repeat it, that the reason why we're having all these issues of people wanting to go to court and etc., it's because I think as a country we've become very highly politically opinionated. You know, we take positions and we would like to get the law to interpret that positions in the manner that we are doing our politics. I have said here, and you know, the decision of the Court of Appeal is very clear on eligibility. They themselves pronounced that anybody who has assumed office of the President in the manner that Dr. Lungu, you know, they went at lengths to describe how the constitutional order has developed in the country. And from those long analyses of the constitutional order that we've had since 1964 up to now, that's where they drew this conclusion that anybody who has assumed office in the manner that Dr. Lungu actually did should not be prevented from seeking office for the third term, because the first term that he served, or the first period that he served, was actually less than what was prescribed for in the Constitution for it to be credited to him.
So does this create a situation of uncertainty? I didn't ask that.
Politically, it does, you know, but in terms of strict interpretation of the law, I don't think it does, because this is the same court that made this decision. So anybody who is going to dare to take this matter back to the same court, they will just, somebody has to just point to what their reasoning was in the case, you know, that we're discussing right now. So politically, yes, it does, because you see, like I said, we have become so highly politically opinionated. People move around in their political opinion, and sometimes we do not draw a line between what is constitutional and what is political. What is constitutional is contained in the Constitution itself. And by the way, the Constitution is a supreme law. Even our politics are subservient to the Constitution. So if people choose to use the Constitution as a guide to what we're going to do, there shouldn't be this uncertainty.
Maybe I need to ask you this, and if you're able to delve into the issues that were given by the people that opposed this decision, that are opposing this decision, the issues they took to court.
No, the people that took this matter to court.
Danpule took the issue to court,
that's right.
Yes, but yes. We had interest groups that
yes.
joined the case
yes.
and said the president really did not qualify to stand. What are the issues that were in that?
Well, I think I can't speak to the issues in this short interview that we have, but the issue, if you remember very well, it is basically the interpretation of those clauses that talk about twice held office and how somebody becomes eligible to be re-elected. And for me, whatever they went around canvassing, there were only two issues that the court had to make a determination on. How do you work on this shrouded constitutional order, starting with the constitution that was in place in 2015 when the first election took place, and the constitutional order that was in place in 2016 when the second election took place. And I think the court acquitted itself very well. They discussed the concept constitutionally, how it sits, and they came to a conclusion that you cannot isolate these two. You would still have to consider what the constitutional order that was there in 2015 was, and the current one that we are operating under. And in their conclusion, even if there was a period of struggle between the old constitutional order and the new one, you should always consider that anybody who is elected to go and finish a less than 3-year term for the president who passes on in office should not have that credited to him. So for them, even if they didn't pronounce, they didn't include the name of the president, Dr. Lungu, the court believed very sincerely that anybody who serves a period similar to what, equal to what Dr. Lungu has served in the first election should not be prevented from considering subsequent application to be elected.
So how does this get resolved? Because the others are holding on and saying it doesn't matter how long you serve. Just you were elected twice, you've served twice.
But the
doesn't
same
matter whether
constitution,
you've
Mr.
served
Zulu, provides for the period. The same constitution that we're dealing with has a specific provision that if you are elected into office and you are going to serve for less than 3 years, that should not be credited to you to determine whether you are electable in subsequent years or not. And try and take that interpretation and give it to the scenario that Dr. Lungu finds himself in. In 2015, it's a given. He was elected, he only was in office for less than 2 years. There was another election. And if you take that period and find a constitutional provision that deals with that, you will see that it's the one that says you cannot use that to prevent him from seeking further re-election.
Is there a contradiction here when you look at it yourself, when you look at this constitution?
Is
there a contradiction? In one breath, it prevents you from standing if you're elected twice,
yes,
and you've held office twice.
Yes.
And in one breath, it says, well, a term is only up to 3 years. That's when it can be considered a term.
There is no
Isn't that a contradiction?
No,
because in one clause,
yes,
it's just very categorical.
Yeah.
If you're elected twice,
yes,
you cannot stand again.
There is
if you've held office twice,
yes,
you cannot stand again.
That's right. There is actually no contradiction if you follow the way I've explained it. Firstly, a presidential term is 5 years. So if you have been elected twice for 5 years, there's no question you are not eligible for election for the third time because you'll have served your 10-year period if you've survived both terms. But if you are elected to go, if you were elected to go and finish the term of the president who dies under the previous constitutional order, what the constitution provides is that your term, even if it's less than 5 years, it must be at least 3 years before you can be considered ineligible to contest the subsequent terms. In other words, if you were elected and served 2 years, and then you come back and apply to be elected and you serve another 5 years, you are not considered ineligible to contest on the third time because you've served for 2 years. But if you had been elected to serve for the 3 years, or the remainder of the 3 years of a deceased president, and then you are re-elected again for another term of 5 years, which takes you to 8, then in that 8-year period, you will not be eligible to contest a third time. That is what they intended to do. And this was basically, intended to ensure that you need to accommodate all the interests. It should be attractive for me to go and seek to be elected in the old constitutional order before we changed to the current one. If a president dies in office and I think I'm the one who's better suited to go and finish that term, I should not begin to have second thoughts of whether I'm going to find a difficulty to get subsequent eligibility issues arising against me. I should be motivated to go and finish that term. And if I'm going to finish a 2-year term, then when I go into my second elected period, which is 5 years, that should be considered to be my first year, my first 5 years, my first term. So there is no.
But that applies to the constitution before 2016.
Yes,
because for now, when you take over as vice president, you're not elected.
Under the current order, we don't even have a problem. If you take over as there won't be an election. If the president dies in office today, the vice president takes over and runs the remainder of the term. But if that remainder of the term is 3 years, the same nomenclature will apply to them. But if it's less than 3 years, then they should also be allowed to recontest 2 more times or 5 years each because they served less than 3 years.
Let's look at the words here. And people say the law does not apply retrogressively unless it's expressly stated so. And in this case, the law, can it be applied to Dr. Lungu?
If you read this judgment, the court was alive to the fact that the first election of Dr. Lungu took place in between 2 constitutional orders. And the court
It was before 2016, before the 2016 constitution?
That's right. So that first election took place under the 2015, under the old election, the constitution. The second election took place under the new constitutional order. And that's the reason why this issue arose. How does somebody who has served under 2 constitutional orders, how can he be considered vis-a-vis the provisions of the current constitution? They addressed themselves to that issue. They looked at the law, and they interpreted themselves what the law is, and they came to a conclusion that you cannot isolate these 2. If there's a straddle, you have to consider that both constitutional orders deal with the issue of the eligibility and that issue of being elected twice. And insofar as they are concerned, as long as Dr. Lungu served for less than 2 years in the first term that he was elected to finish Mr. Sata's term, you cannot credit it to him and prevent him from contesting the third term like he's going to contest in 2021. Because insofar as their understanding of what transpired there, his real first term started in 2016 when he was elected under the current constitutional order.
Does it really apply? Does this law apply to? Can it apply to him? Because I mean, it took effect well after he had been elected.
Which law?
Well after he served he had served his first term.
Yes, like I've explained, they dealt with that matter. They dealt with the two constitutional orders that existed. You know, before the first election took place under the constitution, which was before the amendment, the Act number 2 of 2016, and they resolved the reason that there was a straddle. In other words, he moved between two constitutional orders. But even having regard to what transpired, they still concluded that he should be considered to have been elected to go and finish the term of the deceased president, which under the previous constitutional order he was entitled to do. And if under that order he was only able to serve that remainder and it's less than 3 years, then you can't credit it to him. So it still applies to him.
So would you blame drafters of this constitution for the fact that they didn't take care of the transitional period?
I am not one to apportion blame because I know that the way jurisprudence operates, where the drafters fall short, the court, in exercising its inherent jurisdiction, has got authority to put an interpretation to find the intention of Parliament in passing an election. And it has happened in this country so many years, so many times. The court itself, in the case that we're discussing, referred to instances where they've had to take the position of the drafters and said, look, this is what they must have intended to do. And in analyzing those cases that the Supreme Court had decided before, they then borrowed and said, even in this case, that was what they were going to do. And they did it. They basically closed whatever lacuna had remained. In my view, I don't think that the drafters had made a fundamental error by not providing for transition. Even the court acknowledged that actually they had made that error was there. But the court exercised its jurisdiction, which is allowed in jurisprudence, to enter the fray and provide a purposeful interpretation of the existing clauses to come up with a conclusion.
Maybe I should ask, you're a lawyer and you've got your lawyer colleagues arguing out there, yes, against and for. Why is the debate still on?
If I'm going to answer you as a lawyer, I'll tell you that that's what is in the making of what it means to be a lawyer. You know, lawyers always see from different viewpoints. But in a case where there's clear clarity, like I think there is in this case, there shouldn't be any difference of opinion. There are cases where you think it's borderline. Yes, somebody will have his own interpretation, the other person will have his own interpretation, and this is why we end up going to court to go and find out whether my interpretation of what is on the ground is correct and whether somebody's interpretation of what is on the ground is correct. But if I could just refer you to what the court itself decided in this case, for me, I think it offers clarity as to whether the lawyer should actually be debating this issue. You see, if you permit me, I'm going to just read through.
Please go ahead.
Okay. The court on page J82 said, it follows that Article 106 cannot be isolated from each other in interpreting the article. As we have already stated above, an interpretation of a constitutional provision that isolates the provisions touching on the same subject is faulty. Therefore, to state that Article 1063 applies to a term that has straddled two constitutional regimes, but that Article 1066 does not, is to isolate Article 1063 from the rest of the provisions of Article 106, which is untenable at law. Which is untenable at law, and at variance with the tenets of constitutional interpretation, as all provision on the tenure of the office must be read together. We are of the considered view that the provision regarding the full term must be applied to defining what is meant by twice held office under Article 103 in interpreting the provisions of that article. It therefore follows that the current case, the term served which sits astride the pre- and post-2016 constitutional amendment, and having looked at the intention of the legislature, as we have done, and the holistic approach that we have taken interpreting Article 106 of the Constitution in its entirety, our answer to the question that we have rephrased is that the presidential term of office ran from 25 January 2015 to 13 September 2016 and straddled two constitutional regimes and cannot be considered as a full term. So they themselves made a conclusion that he didn't serve a full term, even if that there was a straddle between the old constitutional order and the new constitutional order. And therefore, his full term can only be considered to have started in 2016 when he was elected for the second time. So they shouldn't, when the court makes a decision of this nature, in my assessment, there shouldn't be any doubt as to whether what the intended object was. They intended to put it beyond doubt that if you serve for less than, in the circumstances that Dr. Lungu has served, that cannot prevent you from seeking re-election in subsequent years, because your first term will be determined when you apply for election for a term of 5 years for yourself.
Now, there's a question that the courts refused to pronounce on and said it had been considered arduous.
Yeah.
Maybe you'd want to explain that to the viewer.
Well, because you see, like I said, they had wanted to make a determination that deals with one issue and prevents a scenario where other people can come to court to seek reliefs on the same issues that were before the court. And what was before the court at that time was whether a person that was serving, that had served in the circumstances that Dr. Lungu has served, could be prevented could be considered to be ineligible for re-election, having regard to the interpretation of Article 106 of the Constitution. And for them, when they made that finding, any other issue that was before the court, they considered arduous, because that was the final determination that they came to.
That's a legal term, arduous. What does it mean?
It became irrelevant. They didn't need to get into determining the other matters that had been put before the court.
I know that the court, I did ask you, why are we still debating? The court clearly stated that amendments provided two scenarios. One, where a president could serve for 8 years, or a total of almost 13 years.
Yes.
Does this really just settle everything?
For me, that goes into exactly what I've just explained here. That you see, in the interpretation of Article 106 and its import and its intent, somebody can serve for 8 years, somebody can also serve for 12 years under these scenarios, depending on whether it can be established that when he was first elected, he went and served for less than the 3 years that is provided for in the Constitution. So even the court itself reasoned like that. So for me, it leads to the same conclusion that I've just been telling you, that the court made this matter determinately, and they resolved this issue.
Do you think any case going back to the court on this matter would still be entertained?
I wouldn't sit here and speak for the court. The court sits as an arbiter. What I would just say is that in my assessment of what transpired, there would be entirely no reason for anybody to go and litigate on the same subject that was litigated upon. But if I was sitting in the position of, the person that applies for nomination and I'm challenged, I would remind the court of the decision they themselves made. So I would remind the court that this matter came before you, even if you are dealing with it on the matter of principle, you made a decision that in your interpretation of Article 106, a person who has served in the circumstances similar to where Dr. Lungu has served should not be considered ineligible to file for nomination in subsequent years.
So now when you look at these clauses and the debate that it has attracted, do you think people should have gone back to the Constitution and amended it to make this very clear? Was this a subject of Bill 10?
That's right, yes. Well, I wouldn't want to argue Bill 10 vis-a-vis what we're discussing here on the issue of eligibility. But you see, broadly and generally, Bill 10 was intended to clean up some of the problems that arose with the enactment of Act Number 2 of 2016. If you remember what happened in Act Number 2, there had been an attempt to do an overhaul of the Constitution under the PF manifesto. In fact, for me, the PF manifesto of 2011 and even the one for the subsequent one were the most attractive in terms of governance and constitutional management of the country were concerned. We intended to bring to the fore everything that had happened between Chwana Commission, Mungamba Commission, Mvunga Commission, all closed up together and the task force was asked to do, a very good job. Unfortunately, because again of politics, we seemed to have strayed. But the amendment of 2016 was intended to respond to the people's needs and also to reflect the fact that PF remained alive to the fact that they were elected into office on the basis of a promise to deliver what was called the people-driven constitution. So that even if we didn't end up with a people-driven constitution, at least Article 2 of 2016 was intended to achieve most of what would have resulted in the amendment if we had done an overhaul of the constitution. And when Dr. Lungu took over as president, he didn't mince his words. He said he was going to take the constitution back to parliament and amend it. With those demonstrations of good intent, I was president of LAZ at that time when that constitution was amended, and people actually criticized me for having gone to heroes when you're signing the constitution. But for me and my counsel at that time, we had come to the conclusion that at least we have attempted to achieve something in trying to streamline the constitutional order. And Article 2, Act number 2 responded to it. But immediately after the Constitution was enacted, it was discovered that it had a few lacunas. I think even all these issues that we're discussing here, they came to the fore, including the issue of what happens when a presidential petition is filed in the Constitutional Court. And these attempts have now been made, and parties, stakeholders were consulted, parties were spoken to, and we end up with Bill 10. Unfortunately, you've seen the politics around Bill 10. I would not run away from the fact that sometimes as a country, we politicize even what we ought not to politicize. I think if we had not politicized Bill 10, we would have enacted it and would have streamlined some of the problems that we're facing right now, in the constitutional order of the country. I still believe that Zambia is yet to achieve the most effective constitutional order. But between the time that we're doing politics and the time we actually reach that objective, something must be done, and which is what Bill 10 had intended to do. And I'm aware that most of the stakeholders, even those who walked away from Parliament, they originally were involved in the genesis of Bill 10. So all of us were speaking the same language. We wanted to ensure that this is enacted. But because personal and political interests came to the fore, we failed to deliver Bill 10 to the people. And we still have these problems.
So
and then if in this scenario, we now give the Constitutional Court and even the High Court, much bigger responsibilities to give us some interpretation of all these clauses that people seem to be having difference of opinion on.
So the debate is basically on 3 words. Term of office,
yes.
Held office,
yes.
Twice elected.
Yes. But also it is laced with politics, because it must be easier.
Well, I mean, these terms are not political themselves.
They're not. They're constitutional. They're
Twice held.
Yes.
Twice elected.
Yes.
Term of office.
And if you read them, together, you will find an interpretation that is very clear. If you just dare not to be political and read them, all along together, you definitely come to a conclusion that it's as simple as this. And this Constitution is very good because it provides for the need for somebody to use common sense to interpret it. This issue is as simple as, you are considered to be a person suitable to succeed the president who has just died. You look at the tenure that has remained, and you've got 2 years, and you know that you're the only one who can go past the post. What do you do? Do you decide to be selfish and say, look, I will let somebody, Mr. Zulu, Gervasio Zulu, go in, either win or lose, and when it comes to starting a 5-year term, that's what I'm going to. And leadership is about the people. If the people say they want this person, and you know that you are equal to the task, you should be able to go and succeed the deceased president without having to worry about what's going to happen to you, because you have made your own assessment. You make the assessment whether it's 3 years and therefore I'll go for 3 years and another 5 years, which is 8 years, I'm locked in, I'll provide leadership. Or it is less than 3 years and therefore if I go in, I'll go for 2 years plus my 2 5-year terms. You must have that freedom to make that decision. And the people that support you must be able to, to support you on the basis that this man has reflected, he has examined the constitutional provision and he has gone in. It's as simple as that. But when you begin to lace even such a simple constitutional transition with politics, this is where we end up ourselves. That if we are dealing with issues that are constitutional dictates, we should be less political and more constitutional.
So maybe it's the way these clauses are placed, because when you have the twice elected placed high up, when you're talking about the president being elected.
Yes,
then you've got the term of office just right below where you're discussing the vice president.
It's not even, you see, Article 9 in the Constitution has the same import as Article 15 in the Constitution. The positioning is regardless. What you just need to be able to do is to give yourself what is called a purposeful interpretation of the Constitution. Take an example of what the Constitutional Court found itself with. It found itself confronted with a Constitution which didn't provide for transition. They didn't develop a heart attack. They didn't collapse. They knew the next thing they had to do. It was to give purpose to the provisions and seek out what the intent of Parliament was. And maybe they have the privilege because they're not as political as the rest of the country is. But what they did is once they saw that there was a handicap in the interpretation of these constitutional provisions, they sought out to pull out the intention of Parliament. And when they pulled it out, they drew their own conclusions, which I've just read to you.
Now, in all this, and maybe in other cases, you've been LAZ president. We've seen maybe a practice or a trend of people trying to go for the judiciary, and sometimes even for persons sitting on the bench. Mm-hmm. How do you look at that?
I issued, I think, not less than 10 statements when I was the president of LAZ, trying to call upon the nation not to be personal when dealing with issues that have to do with the judiciary. because the judiciary, in the setting of government, it is the weakest link among us the three. There's the executive, the legislature, and the judiciary. Weakest not in the sense of, not in the loose sense of the word, but weakest because in every constitutional order, the judiciary has no ability to stand up and defend itself. Its responsibility starts and ends with interpreting the law. And in Commonwealth settings, it is the profession, the legal profession, that actually stands up to defend the judiciary. And that's why, if you recall, when I was president of LAZ between 2014 and 2016, I issued a number of statements whenever I heard anybody, be it from the Patriotic Front or the opposition, stand up to criticize judges. Because judges must be allowed to do their work in an environment where they are seen to be enjoying the security of tenure. So even when I'm sitting here as a member of parliament, for Lukasha and a politician for the Patriotic Front, the call that I can make is what every other lawyer and every other citizen who's discerning in the country would make. That, look, these people, there's a constitutional order that gives them that responsibility to discharge the judicial function of the nation. And being an institution that can never defend itself, apart from when they are sitting on the bench and pronouncing, on the rights and liberties and obligations of citizens, we all owe them the obligation to respect them and to respect the decision that they make, particularly when it has to do with, attacking judges personally. I know that there's a growing trend where judges are being attacked left, right, and center. This is a culture that we should never allow to grow beyond where it is. If I could use a term, we should possibly nip it in the bud if it's still in the bud, because once we reduce the esteem of the judiciary in the judging public, then we'll be reducing the profile of jurisprudence in our country. Let them be free to carry out their work. Let them be free to make determinations that are very clear, because they set the pace of life in society.
Mm-hmm. Before we leave this topic, I want you to still address it. Mm-hmm. I know, like I mentioned earlier in my questions, there should be a bit of panic in either camp. I mean, one camp says, well, we've already drafted the petition, and we're just waiting for President Lungu to file in his nominations. Then we present the petition.
Yeah. My president is not panicking about that. He is very sober about it, and I think his advisors have assured him that everything is fine. And I don't think there's any cause for panic. Those who would want to go and file these petitions, I think will be exercising their rights. But you see, it's one thing to take a matter to court. It's a completely different thing to get victory in court. Sometimes you need to assess what is prevailing. And what is prevailing here, there's a constitutional order that has been created by the Concord decision in the case of Danny Pule. And if you soberly consider this case, there would be no difficulty in saying, look, let's allow all the aspiring presidential candidates to file their applications, and let's go and campaign on the basis of what have you done.
Step by step, maybe you needed to explain what makes these planned petitions weak.
I haven't seen what they are doing. I wouldn't even want to speak to whether they are strong or weak. I am going to speak only to the fact that there's a constitutional order that has been set already by the Constitutional Court in this matter. I can remind you that when I appeared before the Select Committee, when we were actually amending the Constitution, and even when we were appointing Concord judges, I made this position, and I still make it even today. We are now a constitutional democracy. Our democracy is restricted by two things. Firstly, by what is provided for in the Constitution, and second, by what is pronounced by those courts, those judges when they're sitting as Constitutional Court judges. That is the measure of democracy. So it's no longer a democracy where anybody can do whatever they would like to do. So for me, I am a lawyer, and I think a citizen who would like to always respect what the Constitutional Court says, even if I don't agree with it. Because by creating a constitution that provides for a Constitutional Court, one, and by appointing people to sit as judges in the Constitutional Court, we make a declaration as citizens that they will be the measure of our democracy. So if they make a decision in court, we will all respect it. And if we feel that they should revisit it, another opportunity can be created and go back to court. We should not, in my view, lumber them with endless petitions to determine even some of the most endemic issues that we face ourselves with. We should allow them to discharge their functions of interpreting this constitution on matters that are very imperative. Mm-hmm. This, I think, was imperative when there was that disquiet about, the next election has taken place under the 2016 constitution and Dr. Lungu has not been elected twice. It was imperative at that time to bring this matter to the fore. But the court has made a pronouncement. And our responsibility as citizens, and especially as lawyers, to respect what the court has determined.
And to explain it, and in your view, twice elected, twice held office does not count
Maybe
as long as the term of office is less than 3 years.
Yeah, the reality is that read the Constitution in its entirety as the court has guided, and once you do that, you find that the interpretation that we're giving you is a correct interpretation. People should be encouraged to do what Dr. Lungu did. You know, when it became very clear that he needed to succeed Mr. Michael Sata, he accepted that position. Of course, there was a different constitutional order that allowed him to exercise those rights at that time. But even the struggle that took place did not prevent him, you know, it should not negatively impact on him because of what he chose to do at that time.
As we close, maybe you'd want to go back to Lukasha and and look at what is the vision for the people of Lukasha.
You know, Lukasha is a very exciting constituency. It's an agrarian constituency, like I was saying. There's so much that can be done in terms of agriculture. It exhibits a very huge agricultural potential. And so is every other constituency, I think, in Northern Province and even Wapula Province. I think what I want to go and do is to do a plan with, the residents of Lukasha. I'm only there to provide leadership. One thing I've discovered about Lukasha constituency, I won't speak for others, is basically that they know what they want. All they need is somebody to lead them. You just need to do a little thing for them. They'll go a long way. You know, if they say, we want you to help us construct a health post here, before you know it, they will have brought their own blocks on the ground, and you get motivated to, speak to Mr. Zulu and somebody else. Let's get cement here and put a roof on this thing, and it is all done. In terms of agriculture, they are very hardworking people. All they just need is somebody who can, like I said, just to them and give them that leadership. So my vision is to help them achieve their agricultural potential. And also my vision is to make sure that, we pull out most of our children from where they are. There is a high level of girl child dropouts from schools, and we are in programs of trying to bring those kids back into school, and it's working very, very well. We've got partners that we're utilizing, but even the villagers themselves, they're beginning to come alive to the fact that, a girl child must be given the opportunity to finish school, even when circumstances seem very difficult. So we are going back there. We are rolling out that plan for girl children. I also am passionate about the young the youth, the young boys and men in Lukasha constituency. I have noticed that society has been talking too much about girl children. I think we abandoned our sons. So I have programs even for the youths themselves. There are so many youths that have finished school, they're not doing anything. We need to try and see how we can help them to realize their entrepreneurial abilities. And are being supported very, very effectively by the Republican president, I can say that. So I know that we are going to achieve all these objectives because I'm sitting with the right team.
Mr. Chisanga, thank you so much for your time.
Thank you very much. I'm delighted to be here. Like I said, the last time I was here, I was LAZ President. It's better to get here again wearing a different...
As a lawmaker.
But thank you very, very much for the opportunity.
Well, you're welcome. You've been watching Sunday Interview, and our guest this evening was former LAZ President and Lukasha Member of Parliament, Mr. George Chisanga. We'll be back next week sometime. Pleasant viewing.
Distinguished countrymen and women, ladies and gentlemen, it is my honor and privilege to address the nation on this day, which is the eve of the commencement of the 2020 voter registration exercise. Countrymen and women, as you are aware, the Electoral Commission of Zambia has been preparing for this important exercise for a while now. Voter registration is one of the constitutional functions